Hello and welcome to March 2026 webinar series, Personal Wealth Strategies, talking specifically about trusts. And we're going to try to make this as exciting as possible that it can be for trusts. I know it could be a boring, dry topic. And we do want to make clear, this is Justin Rice, a certified financial planner, certified student loan professional, David Bailin, AIF, ChFC, a bunch of other designations as well. But none of those designations or degrees are a JD. So we are not attorneys. We are not giving you legal advice on this call. But what we are here to do is educate you in general about what trusts are, how we see trusts through our financial planning practice, and how we see potential mistakes that can happen with trusts, people thinking they can do things that they can't, or reasons why you should consider a trust and have a qualified attorney draft that trust for you, because we don't do that drafting. So this is educational in nature. So I just wanted to make that clear up front. So I do have some slides here for today, and I will start that off. But David, why don't you give a quick intro of yourself?
Okay, well, for those who don't know me, I'm David Bailin. The rest of those designations are I'm an AIF, I'm a ChFC, a CLU, and a CLTC. And if anyone wants to know what all that spells, it means that I've just done a lot of education. Um, but in today's topic, should you have a trust? I'm going to boil it down to a very simple answer. Should you have a trust? The answer is if there's a benefit to be derived from having a trust, you should have a trust. So now, we're going to take the rest of the time to tell you what some of the benefits of owning a trust might be.
Awesome. And so there's kind of 6 key topics that we're going to be discussing today. Number one, we're going to go through probate, what that is, something you've probably heard of and dealt with if you've been an executor on an estate. The kind of trust 101 definitions, who's involved, the different types, the question at hand, why use a trust? And then what are some special considerations, limitations, and then taxes as a part of that as well, because there are some tax considerations to use with a trust, but it's not a magical tax shelter like some people on the internet may sell it as. And then just final wrapping up. And we do have a Q&A section, so if you have specific questions, feel free to drop those into the Q&A, and we'll be able to handle those live. That's one of the benefits of coming to this call live. And then we will have replays as well. So let's just start off with, probate. And this, for some people, it's like, oh, I want to avoid probate. It's kind of like a dirty word, but what is it? Well, really, probate is that legal process after someone has physically passed away, before they're financially passed away and all of their assets are distributed. So it's that kind of process in between after someone has died, but all of their assets are still kind of in the ownership of the estate and need to get distributed out. And so also as well, typically this would be within your state of residence that you would go through the probate. But if you own property in other states, then you could potentially, go through some ancillary probate in those states as well, and have that to consider as part of, your overall estate. David, anything potential to add to probate?
No, it's a good point because there are people who own property, particularly real property in other states, perhaps where I am here in Florida. You might be living in the Northeast and get tired of the snow and decide to buy a place in Florida. And when you pass away, that means your executor is going to have to meet with 2 different court systems to settle your estate.
Yep. And another thing about probate as well is that it's a very public process. It is also potentially a costly process, and it can take time to transition. So these are some of the potential downsides and limitations of probate, and it can be stressful for heirs to navigate it. So there are benefits of avoiding probate. It's not the end of the world if you have some assets go through probate, but you avoid these downsides potentially by avoiding probate, so you can move assets quicker, more privately, and a little bit of a less stress point of view. So David, obviously we're talking about trusts. That's one way to potentially avoid probate. What are some of the other ways that we can avoid probate?
Sure. There are a number of assets that don't go through the probate process even at all. So assets that have a named beneficiary, think about life insurance, think about an IRA account, think annuities. All these types of contracts have a named beneficiary on it. And this is one of the reasons why you want to make sure your beneficiaries are up to date. Because if your beneficiary on your life insurance policy is an old girlfriend and your will is up to date, guess what? Your life insurance proceeds are going to your old girlfriend because that's a named beneficiary. Obviously, you want to update your beneficiary in that scenario. But a good example of another type of asset that doesn't go through probate is a jointly owned property, something like your residence. So typically a married couple would own a residence in a joint with rights of survivorship title. And what that means, joint with rights of survivorship, means if one person dies, the other owner, the joint owner, has rights of survivorship. That means they inherit it. They then becomes the sole owner without it going through the probate process. Trusts avoid the probate process, as we'll talk about more as we go in here, go forward. But that is a way to avoid the probate process, is to put assets in trust.
Yep. Yeah, and I think the point of this slide as well is if you solely want to avoid probate, you could do a trust, or you could do, other things as well. So the trust is one way, but it's not the only way, and so that's what we want to, make sure to put across. So let's get into, what is a trust to begin with, and we have to know who the parties are of the trust. At the end of the day, a trust is just a container. It's a vessel that will hold different assets or different things and have a set of instructions called the trust agreement that will dictate, how those assets should be utilized or distributed. So that's all it is. It's a container, and it has a set of instructions on what assets and how they can get dispersed out of that trust. You have the four different parties of the trust, which we'll dive into more deeply in these following slides here. But you have the grantor, which is typically going to be you. If you're interested in setting up a trust, you are the trust creator, you are the grantor. And then you want to make sure to set up your trustees. Potentially, it's becoming more popular to have a trust protector. That's an optional piece of it. And then obviously you have the beneficiaries of who's going to actually receive those assets eventually. But let's break this down a little bit deeper. So David, tell us how a trust gets established. Who is the grantor?
Okay. So the grantor, we're using some legal terms here, but if you think about what a grantor does, they are the ones who put the money into the trust. So a trust itself is a legal document that creates this entity, what we call a trust. The grantor then puts money in some type of asset into that trust that is going to be given eventually to the beneficiary.
Excellent. And so the grantor, they obviously have to fund the trust. They'll transfer assets into the trust. And then they're also the one who typically will name the trustee. And so the trustee is the overlooker of the trust. And they are the ones that, number one, must act in the best interest of the trust and the beneficiaries of the trust to follow the instructions that the grantor laid out. And so this could be a person, a friend, a family member. There's also corporate trustees as well that will serve, that you can hire to serve in this role on the trust. So there's a couple different ways that you can do it, and there's benefits and downsides to each of them. And that's a conversation that you would want to have with your attorney and your financial planner and advisors when you're setting up the trust, so that you know those benefits and downsides. You can also have multiple trustees on as well. And so those trustees, could all have to agree in order for something to happen and be dispersed, or either any one of them could make the final decision. And then finally, you can also set up, successor or contingent trustees that would be able to take over if, something happened to the trustee. You have a backup there that will serve in that role, since, if they no longer, would be able to serve in that role.
And Justin, the most important piece on that page, sorry, if you could flip back just one slide, is that third line down, has a legal duty to follow the terms of the trust. So a common misconception is the trustee is the one who decides what happens with the money or the assets in the trust. And in fact, they have the ability to execute to make the transactions, but they don't have any legal ability to make a decision as to what happens. They can interpret the trust, but they have to follow the directions of the grantor of the trust.
Yep. And again, the grantor is setting those rules, and you can have some judgment call for the trustee in terms of when to distribute those assets and give them more flexibility, but you can also give them less flexibility and set up more strict timelines about how, money is set out. So if you say $5,000 per year is distributed, the trustee can't say, no, I don't like little Jimmy, so I'm not going to distribute the 5,000. But if it says, more vague terminology of, you should distribute the 5,000 if, Jimmy's doing this, 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 and this, and the trustee doesn't think that they're doing that, then they have some leeway to change that. So you have to be very, very careful of the verbiage of the trust, because that will or will not give the trustee the flexibility to be able to act upon it. The final pieces, so the trust protector, again, this is more of an oversight position that will be a watchdog for the trustee, just to make sure that they're acting in the best interest of the trust, of the beneficiaries, to make sure they're following all those rules, and then they would have the potential power to change trustees. They could potentially have some veto power, but this would all have to be set up within that legal document, and you would obviously have to know who your trust protector would be in that specific situations and what powers the trust would be able to grant them. And then finally, probably the easiest to understand, because you've dealt with beneficiaries on your life insurance policy and your retirement accounts. But those are people who are going to eventually receive the distributions from the trust, either the income or the principal, and depending on how the trust is written, the timing of that will depend on when the beneficiaries receive it. So we've kind of been talking trust in generic sense, but there's actually a couple different types of trusts. David, why don't you cover kind of the differences here of a testamentary versus a living trust?
Sure. So a testamentary trust is one that doesn't exist until a person passes away. So it's actually created by the terms of the will. The most common example of a testamentary trust is one where a younger parent creates a trust in the will that says, if I pass away, my children are too young to receive this money. I'm instructing the executor of my estate to create a trust that will hold the money for the benefit of my children. A living trust is a very common type of trust, and it creates a trust that is revocable in most cases, meaning it's created during your lifetime, and you can make changes to it. It can be set up as an irrevocable, which means you can't change it. But the most common example of a living trust is something that you create to remove the assets from the probate process to create a separate set of instructions. So a pretty clear example of this is we've all seen in movies these people who inherit money with some wacky instructions when the person died, that if they don't get married by age 30, the money reverts to somebody else, or you have to marry somebody in the faith. You can create those instructions within the trust, and then the trustee has to be the one who carries that out. If it's a living trust, it gives you the opportunity to make changes along the way while you were alive. And of course, once you pass away, that trust becomes irrevocable.
Yep. Perfect. So let's dive into, you kind of mentioned the revocable versus the irrevocable trust and the differences, but I want to dive in because I think this is where some of the confusion stems, because there's one potential benefit of a trust as we're looking at the potential benefits. One of those is to avoid probate. Both revocable and irrevocable trusts will do that. However, some people set up trusts to protect the assets from creditors. And does it actually do that? Well, the answer is irrevocable trust would do that. The revocable trust may not do that in terms of protecting the assets from the creditors. The revocable trust, you can think of it as you still have control over the assets of the trust. So it's almost an extension of you. It's a different entity, but typically revocable trusts will share your social security number, your tax ID number, and it's just an extension of you. And you can freely put money in, you can freely take money out of the trust, you can change the terms of the trust. You've got complete and flexible control. And since you still have, flexible control, the creditors and other people would still have access to the money since you do. An irrevocable trust, you're basically setting up a separate entity that is unique and separate from you, that is outside of your estate, that you don't have as much control over once you put the money over into that trust. And because once you do that, you don't have the control of that money, then that's when you get the protection from creditors. That's when you would get the protection from, Medicaid with a look back period, which we'll dive into a little bit deeper. But that's the biggest difference between the two. Oh, and the irrevocable trust is outside of your estate, which could come into play if you are subject to any estate taxes or any ramifications of that as well. So you can kind of think of revocable. You've got full control, full flexibility. Even at some point in time, if you no longer want the trust, you can just easily end it. Irrevocable is much more permanent, really can't change the terms or dissolve the trust. Now, if you work with some expert attorneys, there are some scenarios where you'll be able to get out of an irrevocable trust, but for all intents and purposes, you should assume that that's locked and ready to go, can't be changed. And then, as David mentioned, a revocable trust becomes irrevocable upon the grantor's death. Typically. So, you can make the changes while you're alive. If you're no longer alive, then everything is locked in from that point forward. So we've kind of sprinkled in some various reasons of why to use a trust throughout, but here we just wanted to kind of give you the kind of comprehensive list. So David, why don't you share with us some of the key reasons of why a trust might be a useful thing?
Okay, so I started off the session today by saying, should you have a trust? The answer is if you need a benefit that a trust can create. A lot of times we've been asked questions by people, should I have it? Just come to a financial planning meeting. I'm thinking of getting a trust. And when we ask them, well, why? The answer is, well, I just heard it was a good thing to have, or my neighbor has. Well, those aren't the benefits. Here's a list of some of the benefits. So you may want to avoid probate and the delays. So a trust simplifies your estate because it's a set of instructions that says, here's what's happening to my assets. It's not subject to typically to a court review, so it can be acted on almost immediately. It can preserve family harmony because it addresses those issues that the grantor chooses to address. It can be unequal distributions of assets. It can be particular assets that maybe are not easy to split. Perhaps there is a family business with one child who's active in the business and two children who are not. The trust can help get that asset to the child who's active in the business if that's the desire of the grantor. You can protect heirs from poor decisions, creditors, or divorcing spouses. Common concern is what if my child, or my child-in-law, my daughter-in-law, my son-in-law, what if they divorce? Are they going to get the family assets? With a will, I have no control over that, but through a trust, I can limit their access. Enable smooth business succession. I've already mentioned that one. Plan for charitable giving. A lot of times trusts are used for planned charitable giving, and this is something we're talking to our clients a lot about now, planned philanthropy. The idea, different than giving $5 to the Boy Scout who's selling popcorn at the grocery store, planned charitable giving is the idea of I want a portion of my assets to go to a charity. It could be small, it could be large, but I want to address that as part of my planning. Beneficiaries with special needs. If you're not aware, if your beneficiary is on government assistance, typically Medicaid or Social Security income, that those benefits are income tested, and if that beneficiary has income, has assets, they can lose their government support. So by using a trust, you can protect the government support that they're receiving. Prepare for incapacity. This is one that comes up an awful lot with clients as they get older, but there will come a day, or could come a day, where typically it's a mental concern, but it could be a physical one as well, where I may not be capable of managing my assets on my own. And a trust can help in allowing for those assets to be managed in an appropriate manner. Likewise, planning for the expenses surrounding long-term care. If you don't have an insurance policy, if you don't have $1 trillion in the bank account somewhere waiting to be spent, using a trust can help you qualify for government assistance or protect your assets along the way. Shielding assets from creditors and lawsuits. If you use a trust, depending on the type of trust you use, those assets are no longer yours. And therefore, if somebody sues you, they can't access those assets. So you'll hear about that with people who are in very visible occupations, people like politicians or athletes, or people who are likely to litigation, like physicians might use a trust to protect their assets. And finally, to reduce the size of the estate taxes. And one thing that I should have mentioned earlier, Justin, is that a lot of the things we're going to talk about are very state specific. So if you live in one state, we may be talking about something that doesn't have it. You may say, well, that doesn't, why is he talking about that? That doesn't make any sense. If you live in another, you might be saying, well, why don't you spend more time on that? So I will throw in the provision here that when you're thinking about yourself, you do want to get advice along the way and not take this webinar as the be all and end all in trust planning.
Yeah, exactly. Definitely don't do that because there is state specific. So, yeah, the estate taxes, as an example, federally speaking, is $15 million. And so that's going to affect a small percentage of people. And if you're married, it doubles it because you have 15 million each. But if you're in a state that has an estate tax, and sometimes that doesn't offer portability, it's a much more lower threshold. You may be subject to that and be more concerned at the state level versus the federal level. So you definitely have to be state specific in your plannings of the trust as well. And there's some trusts that don't even exist in some states. So let's just kind of go through some of these. We'll kind of go through rapid fire since David did a good job of kind of covering each of them. But avoiding that probate is a benefit of the trust. You have more control. It also, one thing in addition to what David had mentioned, it's harder to contest than a will. So a trust is is not foolproof. If people want, they can try to plug holes in it and say oh, when it was written they weren't of sound mind or whatever. So there's different things that they can do, but it's a lot harder to contest a trust than it is to contest a will. And so that's another thing to keep in mind. And besides the privacy, the faster distribution, the more control of the different instructions, it is a benefit to a trust. Preserving the harmony. All family might love each other until lots of money gets involved, and then all of a sudden it could turn sideways. And so being able to have no court involvement or anything like that, and have the assets spelled out in terms of how they're distributed, and instructions for that, and potentially even some reasonings behind it, helps to prevent some of those fights. Protecting heirs. So David had mentioned this as well, but it gives you control if you have children that are at a young age, where you can have disbursements planned based rather than in a single lump sum based on their ages or different milestones like graduating college, getting married, etc. And so you've got a lot more flexibility than just if it leaves outside of those instructions in the will and you don't have a testamentary trust set up as we discussed before, it would just get passed to them in a lump sum and it would be all available to them at age 18 in most cases. Also, something else to keep in mind is when we're talking about protecting heirs, is there's other specific provisions to protect the money from the heirs themselves. Meaning that if you are worried about a son-in-law or a daughter-in-law coming to steal the family money and you never liked them anyway and want to make sure they don't get anything once the divorce happens because it's going to happen, you can set up various trusts where the heir does not have full access to the money. And therefore, if the heir doesn't have full access to the money, the spouse typically would not be able to get it in some type of divorce proceedings. This is also potential if there are some drug-related issues or some other issues of spending problems, and you want to offer some protections there for the heir so they don't just blow through all of the money, even once they're a certain age. These types of trusts can be set up as well to protect the heir in those circumstances. And then just about the in-laws as well, you see that note at the bottom there. Again, state specific. So you just want to make sure, in the state, in terms of the divorcing spouse, how that works and the various trusts there, just to make sure it does what you want it to do. David, you mentioned the charitable piece of it. Why don't you go specifically kind of what people would do with a trust from a charity perspective?
Sure. Now, when we talk about charitable giving, recognize that you could, during your lifetime, write a check and give it to a charity. And the same way you could, in a will, make a clause in there that says, I want to give $5,000 to the local ASPCA. But a trust allows us to do more in terms of the management of that money. And we don't even get into real in depth here what we're talking about in terms of charitable giving, other than to talk about these idea of irrevocable charitable remainder trust and charitable lead trust. A charitable remainder trust, fancy name, but break it down: charitable intent, charitable beneficiary. Remainder means that the charity gets what's left. Okay, so let's talk about a piece of real estate. We'll use the piece of real estate in both these examples. If I have a charitable remainder trust and I have a rental real estate, I can dictate that that income from the rental property should go to my family, beneficiary, whoever it is, and they can get that income. But when I die, that rental property now can be turned over to a charity, and the charity can do with that property as they wish. Normally, they'll sell that for the proceeds. In a charitable lead trust, it's the exact opposite. Now I take that rental property, and the charity is going to receive that rental income while I'm alive. And at the time I pass away, the property now will pass to my named beneficiaries. The importance of using the trust is that you get a tax deduction for that portion that is attributable to what the charity receives.
Yeah. And so this is one of the instances where a trust would actually be a tax benefit to you because there's that charitable component of it. And that's how, depending on what the goal is, how much you want to give to the charity and when, that's what determines, whether we go charitable remainder trust, whether we go charitable lead trust, are we trying to reduce the estate assets? So those are all the factors that go in to decide the specific type of a charitable trust. But taxes and the tax deduction is a big portion of that because there are benefits of doing that. When we talk about special needs, David covered this as well. You want to protect the heir so that they do not lose access to the Medicaid and supplemental Social Security income benefits. They have income and asset limits. And if a special needs child, person, adult receives a bunch of assets outside of the protections of a trust, that could remove those benefits from them. They'll become ineligible benefits. And so the trust assets designed specifically for the supplemental needs, as it's typically named, are not counted as the beneficiary's resources. And so therefore they don't have a break in those benefits. And that's typically very, very important for those in that situation. You definitely should consult a estate planner in that specific capacity. Now, when we talk about planning for incapacity, there's a couple different ways that we can talk about it. And some of you may be familiar, especially if you work with our office, of a durable power of attorney. And that's typically, how you could deal with incapacity not using a trust, where you give somebody the right to act on your behalf, and it could either be durable, meaning right away, or it could be springing, meaning that it only is enacted once incapacity is proven, and then they can act on your behalf. So you can actually have a springing component there for the incapacity. Now, again, it's state specific, so your state may or may not allow those various provisions, but you do want to potentially consider that if you can no longer act for yourself, who can act for you from a financial perspective, from a medical decision perspective, from end of life care, who has access to your medical information. Like you can have each of those different documents, or you can have a trust to help ensure, from the financial aspect of things, that you have the instructions there. You ensure those assets are used according to those instructions, and then avoid the need for any court appointed guardians, and again, keeping everything private financially. Why don't you talk, David, about you do have the CLTC, the designation long-term care. So why don't you talk about this Medicaid Asset Protection Trust?
Sure. So one of the things that we speak to our clients about is we believe that everybody should have a long-term care plan. Long-term care plan means if the event occurs where you are no longer able to care for yourself, either through physical inability to take care of your basic living needs, or because of mental acuity, compromised mental acuity, we believe that you should know what's going to happen at that point in time, particularly from a financial standpoint. Because if you're trying to deal with the medical side of things at the same time you're trying to figure out how you're going to pay for it all, it's already going to be overwhelming, but that just makes it even more so. But one of the things that you have to decide early on is, do I want to pay for my medical, not once, not the right one. Am I going to be paying for my medical care out of my assets, or am I going to look for the government to pick them up? And if I'm going to look for the government to pick up these costs through Medicaid, I have to position my assets so that I can qualify for Medicaid. And to qualify for Medicaid, you have to prove that you're indigent. You have no assets. Well, how do I prove that I have no assets? I divorce myself. I get rid of my assets. Now I own nothing. And where do I give my assets to? I put my assets into a Medicaid Asset Protection Trust that will manage those assets according to the instructions that I've given, but I no longer have control over those assets. People are probably pretty familiar with this idea that these assets have to be in the trust for at least 5 years before I apply for Medicaid. So it can't be the type of thing where I let it go to the last minute and think I'm going to be able to transfer money at that point in time. But these Medicaid Asset Protection Trusts can help me qualify for Medicaid. For most people who have some level of means, qualifying for Medicaid, while it can sound attractive to get the government to pay for my care, is not a desired goal, because you're also turning over decisions about your medical care to the state. And you can imagine they will not necessarily make those same decisions that you would make about your own medical care.
Yes. And most of the time when we're looking at this as well, and obviously planning is always important, but this 5 years, they've discussed potentially extending that even further. So that's always part of the discussion. And then typically with our clients, we'll create some type of long-term care plan, but the family wants to protect at least something. And so they'll put their primary residence into a Medicaid Asset Protection Trust to just protect the residence so that can get passed down. So worst case scenario, if they do run through all of the assets, worst case, at least the home is protected for their beneficiaries. So it's not an all or nothing thing. You don't have to put everything into the trust so you're poor from dollar one. It could just be your residence that you want to make sure to protect and pass down, and you'll pay for it. And if you have a really extended care, at least that's protected. Another one. So I mentioned one of the benefits is protection from creditors if it's an irrevocable trust. But that doesn't really help you if you give your assets away and then you don't have access to them. So there's kind of this self-settled trust called the Domestic Asset Protection Trust. It's only available in a couple of states, but this is where you still have your ownership of them and control, but it's separated from your personal liability. So technically, they're no longer the grantors. You have to have an independent trustee, but you still have access to your money when you need it. Now you can't do this like at the moment. So you get in a car accident and you're worried somebody's going to sue you. So, oh, hey, let me set this trust up real quick. Or you're a doctor and you have a big malpractice case that you're going through. And it's like, oh man, this is crazy. Let me protect. Like it has to be done beforehand and set up before there's that risk. Because if you do that, that's called fraud. That's not good. So you want to have this set up beforehand so that you can protect your assets, and then you just want to make sure to talk with your planning advisors just to make sure that it is allowable in your state. So, for example, I know in New Jersey, this is not an allowable trust. In New Jersey, they don't have these self-settling rules available in New Jersey, but they do in Delaware. So if you're our neighbor down south in Delaware, they do have this available. Um, so also, as we mentioned, protecting assets from Uncle Sam in an irrevocable trust too to help minimize the estate taxes federally. Now, as we said, the estate taxes are $15 million right now, but there's no guarantee that they'll stay that high. So they've been much lower before, and so if the rules change where it's imminent, where we could get a reduction there, or you're young and your estate is still growing, you definitely want to be able to look at the potential of minimizing any estate taxes. And one of the key differentials between a revocable and an irrevocable trust is that when you take money from the grantor and put it into a revocable trust, nothing happens since you still maintain access and control. However, when you put it into an irrevocable trust, what happens there is it's looked upon as a gift. And so that does go against your eventual gift and estate tax exclusion. And so you want to use that wisely in order to maximize your benefit and minimize your eventual taxes. So if you're in that situation, it can help to minimize those types of taxes. And then again, on a state level as well, you want to pay attention. So what are some other special considerations? Well, when to not use a trust. So we went, through all of the litany of all the different benefits. Well, David, when might a trust not be necessary?
Okay, so I would say that a trust is not necessary if there's another way to accomplish the same goal that you're trying to achieve. Because the trust is going to cost you money, right? You're going to have to see an attorney who's going to have to draft it for you. And although it can simplify things through the execution, it is an extra entity that you have to pay attention to. So if we don't need to use a trust, we don't. But why won't we use a trust? We won't use a trust if the assets that we own have a named beneficiary. And that is because the named beneficiary is a contract, and it says at the time of my death, the insurance company, the IRA company, the bank, the annuity company, they have to follow the instructions that are on file through the beneficiary arrangement. Therefore, those assets do not go to probate.
Yep. Awesome. And now there are some assets that you potentially could or should put into a trust, but there's also assets that you really can't put into a trust. And so if you're like, oh yeah, my estate planning attorney, told me to put all of my assets in the trust, and they come to us and say, all right, can you help me with that? It's like, all right, you got the car, you throw, sure, throw that in there, throw in the brokerage account in there, throw in the bank account, sure, whatever. The IRA, Roth IRA, nope. That's an individual retirement account the ownership can't change to a trust. And in fact, if you do that, you could trigger, taxes, potential penalty because the money would have to come out of the IRA in order to go into a trust. So that's a scenario where you definitely shouldn't put money into a trust. Also, qualified annuities, kind of under that IRA wrapper, would be very problematic if you put them into a trust. So typically, you're not going to want to do that. And then you can have, if you want, so on the IRA, you can name a trust as a beneficiary, a named beneficiary there to then pass it via the trust. But there's a whole nother set of rules for inherited IRAs that are trusts. It's typically better to have a named beneficiary on an IRA. And so these are all of the things that we look at in conjunction with the estate planning attorney in terms of what should have the ownership. Is it the trust or is it you? And then who should be the named beneficiaries on that to reach the goals that you're trying to achieve? But if you just blanket have the trust and say, let me put it everywhere, you may find that wasn't the most efficient use of the trust. And then the final piece that we want to pay attention to is the tax overview of the trust. And a lot of people, for some reason, maybe because more wealthy people tend to set up trusts, is they assume that, well, wealthy people are doing it because they're getting some type of tax break, which could be true in that charitable circumstance or the estate planning circumstance. But in actuality, when you're running the numbers there, are trusts really that good from a tax perspective? Well, As I mentioned, from the estate tax perspective, it can be, but the limits are relatively high right now, and so most likely, unless you're over $30 million for a married couple, or expect to be, you're not going to run into this. And so, if you want to move assets out of the taxable estate, you could reduce or eliminate the estate taxes there. So that's a good use of a tax break. Gift
Hey,
taxes,
Justin, I'm
yeah,
sorry to interrupt.
do it.
Before we go off the taxes, we've said it before, I'm going to say it again. Pay attention to state taxes though, too. So in a state like New Jersey, you can leave assets to many of your family members with no state taxes. In a state like Pennsylvania, you're going to get hit almost $1. In Massachusetts, you get the first $2 million you can leave to a family member other than a spouse. With that. So it varies greatly by state. The 15 million is very comforting because for a lot of people, that means I won't have to worry about the federal government, which is typically the bigger one. But these state taxes, and I've named a couple states around our home office in New Jersey, but let's pick up New York. New York, if you have a $7 million plus estate, the tax is pretty big. You're talking about a six-figure tax just to start. And these numbers, while they sound high, don't forget, you got to add up your life insurance values in there, the death benefits in there. You got to add up your pension benefits. You got to add up your home. 7 million is a big number. 1 million is not, and everything else is in between.
Yeah, yeah. And speaking of life insurance, particularly, that's also a popular asset if you're coming up on the limits to own inside of an irrevocable life insurance trust as well to kind of keep it out of the estate. That's another easy and efficient way to do that if you're, worried that that's going to knock you over. So these are all the different, 201 strategies that we can talk about if they're applicable to you. And then you also want to pay attention to gift taxes. So in an irrevocable situation, you can only gift so much to another person before you have to eat into that eventual estate exemption at the federal level. And so the annual exclusion for 2025 was 19,000. I actually don't know. Did they increase it for 2026? David, I don't even know. I don't think
No,
so. Yeah,
same
so
thing.
19,000. So for example, though, if you have a trust and you have three kids that are the beneficiaries of that trust, you can utilize the annual exclusion for all three of the kids for both you and your spouse. And so once you add that up, that's close to almost $120,000 that you can put in a single year with some certain provisions called the crummy provision. You have to follow those rules. But if you do that, you could seriously fund a lot of money in the trust without even tapping into any of the lifetime exemptions of the 15 million or 30 million dollars for married couples. The only state, we don't get state specific, but Connecticut is a one of one in terms of the only state having a gift tax. Every other state, you can give a gift without any limits, no problem. Again, the federal limit still applies to the $19,000 per year, but Connecticut's the only one where you actually have to worry about a gift tax if you're looking to gift money before you have passed away. And so a trust specifically here would, you can either count it as part of the lifetime gift tax exemption or try to stay under those limits so that you can, put more money outside of your estate. Again, if you're looking to try to reduce the value of your estate that you own for tax purposes. And now the final kicker here from a tax rate when it comes specifically to the trust, and this is actually a pretty significant downside when it comes to the trust, is the assets within the trust is taxed at a very, very high rate. And so these are 2025 numbers, didn't update them for 2026, but there's a little bit of an increase here. But for a married couple filing jointly, you don't hit the top tax bracket until you're over $750,000+ of income. Whereas within a trust, once the trust exceeds $15,651 of income, you're now at the highest tax bracket. And so that's why there's typical provisions in the trust. You don't want to be taxed at the trust level. So typically you're going to have the taxes flow to somebody else, or you're going to manage the trust in a way to drastically minimize income so that you're not paying those super high taxes. But trusts at an income tax rate is very, very inefficient. And so that's definitely something that you have to pay attention to when you're managing assets in a trust. to see how the tax, income tax would pass through. David, anything else to note or add on that?
Just to point of clarity, not all trusts are subject to their own taxation. So a lot of trusts, the tax rate would be the same as the individual rate, but it's staring you right in the face, that bottom line. As Senator Sanders would say, we got to tax the millionaires, the billionaires, and the 15,000aires.
Yes, yes, that is true for sure. So that wraps up, our lesson here on Trusts 101. Hopefully, we were not overwhelming or confusing. It can be confusing, but we try to provide clarity. So if you have any other questions, feel free to drop them into the Q&A, and we'll be able to address those. All right, I do see one coming up in here now. Okay, so 65 years old. Should I put my home into a trust? David, do you want to take that question? This is
Um,
not specific advice. So in general,
the answer is
we don't.
maybe.
Yeah, that's the real answer.
Uh, well, I mean, the answer is definitely maybe. Or need more information. I know what you're getting at. There's a benefit that you saw in the presentation. You say, yeah, there's something there that I want. Maybe at 65, you're thinking about protecting my home from the cost of extended medical care. Or maybe I'm trying to qualify for Medicaid to pay for that extended care. And if that's the case, then it might make sense to put the house in a trust. It may also be that you are thinking about the how the house will be inherited. Maybe you have a complex situation where the house at the time of your death will be inherited by young children who are too young to manage the house. Maybe it will be inherited by somebody who's not capable of managing the house. Maybe it will be managed by, maybe you want to set up management for the property. Maybe it's not your residence, or maybe all your family lives in California and you live in Connecticut and there's nobody there to manage it. So you want to name a management company and a trustee to oversee the management. So there's a lot of reasons why you might want to put it into a trust, but your question didn't give me the reason why.
Oh, good answer. Yeah, that's my favorite answer. Maybe.
But I'm
Maybe
definite
need,
on that,
yeah,
maybe.
yeah, definitely maybe need more information. All right, the final question here, unless anybody else has something they want to put in last minute. Does the asset protection in a trust prevent the need to purchase umbrella liability insurance? David, do you want to take that one as well?
Sure. So if we put an asset into the trust is now the owner. Now, actually, it depends on what kind of trust we're talking about. So if we're talking about a revocable trust, then you still have incidents of ownership and it doesn't give you any liability protection. So the answer there would be if you were going to buy liability insurance for yourself, you got to still buy it. If it's going into an irrevocable trust where you have no incidents of ownership, and this would be probably unusual given the question you're asking, but if you put it into an irrevocable trust where the trust was the outright owner, it doesn't relieve you of any liability. The trust is now liable. So the trust could be sued. And if the trust is sued, the trust could be forced to liquidate its assets to pay the suit, which means that the house that you're trying to protect becomes subject to creditors. It reminds me many years ago, I'm going to show my age here. There was an insurance company when I lived in New Jersey, an auto insurance company that did business in all 50 states. And New Jersey was considered at the time to be the riskiest for them for auto insurance. So what they did was they created one auto insurance company in the state of New Jersey and one that wrote auto insurance in the 49 other states. And they thought if something happened in New Jersey, we could pay off our claims and walk away or protect the other 49 states. Well, a hurricane came in Florida and wiped out the insurance company with the 49 states, and all that was left was the New Jersey company. So separating things from a liability standpoint doesn't necessarily solve the problem. You're still going to, the liability just shifts from you personally to the trust.
Yeah, and in these situations too, umbrella liability insurance is really cheap, like a couple $100 for millions of protection, and so it's pretty easy to add that on in conjunction with your home and auto to be able to offer that much larger layer of protection there. for a very, very low cost. So typically, in our financial plans, we will recommend some form of umbrella insurance in most situations for those of higher net worth.
Yeah, and Justin, this actually makes me think of another scenario. So when we're talking to physicians, not an unusual concern for a physician. What if I get sued? I don't want to lose all my assets. And I use the analogy of a ladder, and you climb up the rungs of the ladder. Okay, so what's the first rung? Well, do things to prevent yourself from getting sued. Put in safety measures. If we're going to talk about house, what am I going to do? I'm going to fix that sidewalk that people might trip over before I start putting my house into trust. Right, there's a simpler solution. Second rung on the ladder is insurance. Physicians don't always think about it, but maybe I should just increase the size of my malpractice insurance if I'm so worried that someone's going to sue me. A lot cheaper and easier than setting up these trusts. In the case of a house, well, can I just increase the amount of insurance on my homeowner's insurance or buy an umbrella policy? So the trust can provide solutions, but they're not always going to be the easiest solution. And that's why you've got to work with an attorney. That's why you got to work with a financial planner, because they're going to be more familiar with all the different options available to you. And when you say, here's what I'm concerned about, or here's the benefit I'm trying to derive, they can tell you a trust might be a consideration, or, why don't you just write up the beneficiary different on your life insurance, and that will solve the problem for free.
Yep. Yep. There you go. All right. Not seeing any more questions come in. Thanks so much, David, for going back and forth with me here. If you have any other questions that pop in your mind, or you're watching this in the replay and you have questions, always feel free to reach out to us. Our emails are available on our website, personalwealthstrategies.com. And, feel free to reach out to us there, or in your next client meeting. If you're a client, have that down. We always ask you what you want to cover. And if there's any particular topics that you have in mind, we'll be happy to discuss those with you. David, why don't you wrap us up and tell us where they can find us next?
Okay, so our next webinar is going to be on April 1st. That is not an April Fool's joke. It actually is April 1st. We'll be at noon. We do these meetings every month, these webinars every month. Topics range from personal to all kinds of different planning topics and financial topics. If you can't make it, I know I put this in the email every time when we send the invitations, but please go to our YouTube channel. Go to YouTube. Hopefully everyone knows how to do that. But then you can type in personal wealth strategies, and you'll see the whole inventory. I don't know the number that we have in there now, Justin. There's dozens and dozens of webinars, and chances are whatever question you have, we've already covered it. But if we haven't, you can also send us an email, and we'll put it on the list of things to cover. Best way to handle that is also to subscribe. You hit the subscribe button, then you'll be notified every time we post something up on that YouTube channel.